Alyssa Soar versus Jordan Soar.
Court will note the appearance of Ms. Thomas on behalf of the plaintiff, Ms. Henderson on behalf of the defendant. This matter is before the court on the defendant's motion to reinstate parenting time. Ms. Henderson.
Good morning, Your Honor. Thank you. On January 23, this court held a hearing on plaintiff's motion to suspend parenting time. At that point, I was not yet retained by Mr. Soar, and unfortunately, he did not appear to the hearing, having received the notice of that hearing just Thursday the week before and not being able to retain counsel. The court did suspend his parenting time. That was the only ruling of the court, and the court stated it would entertain motions to reinstate parenting time. Immediately upon being retained, which was approximately 4:58 p.m. on January 23rd, the day after the day of the hearing, but after the hearing occurred, defendant's counsel emailed plaintiff's counsel asking if a resolution would be possible. I would ask the court to note that plaintiff's counsel provides an untruthful statement in her response stating that I contacted her prior to the hearing, which is completely false. I did not even meet with Mr. Soar until approximately 3:30 p.m. on the day of the hearing, Your Honor. So I would ask the court to note that and see what other things are untruthful in that response provided by plaintiff's counsel. Upon speaking with plaintiff's counsel, it was determined that even though there are no formal rulings made or conditions for reinstatement of parenting time, that my client would undergo an independent psychological evaluation. And immediately upon having agreed on that, my client reached out to Life Coach Psychology, which is located in two offices. One of them is about 15 minutes away from my client's residence and his place of employment in Berrien Springs. He resides in Niles. And so my client scheduled his independent psychological evaluation through my participation on the NA case rotation. I know that Dr. Haugen was at that time booking well into spring. And so Life Coach has been used by this court more often recently because Dr. Haugen is so busy. My client attended the independent psychological evaluation on February 14 and March 2nd and completed a comprehensive evaluation, the result of which was provided to plaintiff's counsel on March 8, 2023. A copy of this evaluation is attached to the motion. I understand that plaintiff's counsel is stating it's hearsay. However, I do have concerns about the court granting the motion based on completely hearsay allegations that were contained in that motion, Your Honor. And had my client appeared, I don't know if the court would have made that ruling. The results of the evaluation verbatim state that there is no evidence that Jordan Soar is an angry and aggressive person, and there is no indication from the evaluation that this would point him to being an unsafe parent. The traits that were revealed in the test have no bearing on the quality of his parenting of his children, Your Honor. There were no specific recommendations made based on nothing essentially harmful in his behavior or traits found as relates to parenting. However, Mr. Soar re-engaged in weekly counseling through Life Coach Psychology that he has been attending at this point every week after work. During that counseling, Your Honor, he is working on healthy relationships. He is working on issues of substance abuse, any other issues that were mentioned in the independent psychological evaluation, such as anxiety, insecurity, and difficulty with socialization. And at this point, defendant has done what was communicated with plaintiff's counsel. He is willing to provide any and all releases necessary for Ms. Thomas to review his progress. He is willing to continue and plans to continue that counseling on a weekly basis. Your Honor, we're asking that his parenting time be reinstated. Any of our requests resulted in very brief video parenting time, mostly with his daughter, Mia. However, I do have to say that after the filing of the motion, Plaintiff allowed the son to call my client, Brody, and Brody acted like nothing happened, told his dad he missed him. So clearly the allegations of him being afraid or not wanting to have any contact with my client do not check out at this point, Your Honor. We're asking that my client be granted his parenting time that he has pursuant to the judgment of divorce. He has spring break this year with the children. He would like to exercise this parenting time. He is willing to have his mother supervised it if that makes plaintiff more comfortable. He is going to continue mental health treatment, Your Honor, at this point. He is willing to do whatever the court needs him to do to get his children back. However, I think he has shown through his participation in the evaluation and counseling already that he is acting upon his desire to see his children again. Thank you, Your Honor.
Ms. Thomas, what's your response, and address, if you would, if there's any, your client's agreeable if in fact the paternal grandmother does supervise?
Okay, thank you, Your Honor. Your Honor, first of all, I would apologize that I noticed that our response had the former counsel as opposed to Ms. Henderson on it. I do take exception to Ms. Henderson's comments this morning regarding what time of the day we spoke on that Monday. In that I leave at 4 p.m. on Monday, every Monday, so that's not correct. So I'm not sure what that's about, but whatever. Although counsel alleges that the order of this court was based upon false allegations, defendant did nothing to let this court know and or otherwise, acknowledge that he was even aware of what was going on. He obviously, now we know he did have notice, he had proper notice. He failed and or refused to attend the January 23rd, 2023 hearing, even though he knew it was about having his parenting time suspended. He still did not attend. And that's interesting because it's not as though he didn't know how to ask for an adjournment, because in fact, he had asked for an adjournment in the enforcement portion of this case. So he did know how to ask, he just didn't. Since immediately prior to the entry of the judgment of divorce, the defendant has repeatedly alleged plaintiff is lying to the court, but is yet to offer any evidence of same. And in fact, failed to file an answer to this or otherwise respond to this present motion. There still is not a response to this motion in the court file, allowing this court to believe that the allegations that were made by plaintiff are in fact truthful. And that did support a suspension of parenting time. The suspension of parenting time was not about plaintiff attempting to interfere in defendant's relationship with the minor children. Rather, it was based upon the party's son, his unusual response to the parenting time that happened at defendant's home over New Year's weekend, when he cried and begged to not have to go back to his dad's home and begged to talk to Your Honor personally, explaining to you why he shouldn't have to do that. After he had previously always looked forward to going to dad's house. He'd always wanted to go. He'd always looked forward to going. He knew that there's limited rules and he wanted that. That combined with the defendant's history of mental health issues, his violation of the plaintiff's personal protection order against him, and then plaintiff becoming aware that there was domestic violence at plaintiff's home, and apparently that weekend, not in front of the children, but apparently it wasn't the first time of domestic violence in defendant's home. And therefore, in that time, our plaintiff's understanding is that the plaintiff's then girlfriend ended up with broken ribs. So clearly there's a lot more than what counsel would have this court believe. After conferring actually with the defendant's mother, that's when, in fact, plaintiff decided that, the parenting weekend was missed. And based upon the totality of all of that, she decided that this was the absolute only way to go at this point. Although there was an agreement that a psychological evaluation should occur, defendant, at the apparent discretion of or direction of his counsel, selected his own evaluator, wherein, as we had requested, Dr. Haugen. I note that Lady Henderson did indicate this morning that Dr. Haugen is gone apparently until spring, but that's not true. I have talked to Dr. Haugen numerous times over the past 3 weeks, so definitely that's not the case. He's, in fact, I could have gotten him in that same week. I just didn't know until after that was the day of the appointment that I found out. So obviously it was too late. The purpose of the evaluation was to determine the presence of anger and or aggressive issues, and was to be inclusive of an alcohol and drug assessment, which has not yet been completed. The defendant has a history of mental health issues, which led to the inclusion of language in the judgment of divorce. The defendant shall follow all recommendations, referrals from his current healthcare provider regarding mental health treatment. He has failed to comply with that directive. More importantly, the party's minor son is experiencing some significant trauma at the thought of having to go to in-person contact with defendant. He's working with the resilience coach at his school, which is a Mr. Tramonday, and he's helping him kind of with his emotions, but also helping him with skills to kind of help when Brody's frustrated. Both children are scheduled for counseling evaluations to determine their needs. Even though there is no order for plaintiff to do so, she has in fact been allowing telephone and video chat contact with the defendant. The older minor child is still extremely upset and refused to have any contact for several sessions. He then has agreed to do one. He was okay. Again, that was with the help and guidance of the resilience coach from his school. Defendant was given the younger minor child's soccer schedule, inviting him to games, and he failed to go to any of her games, similar to the way he fails to exercise his Wednesday evening parenting time. Once the children have been evaluated, there can be a better directive as to the children's best interests and what is best for them. Meanwhile, defendant has failed to comply with the judgment of divorce and did not undergo drug and alcohol assessment as counsel had agreed. Finally, plaintiff objects to the inclusion of defendant's exhibit, obviously, as it includes double hearsay and cites not only an incorrect reason for the evaluation and lays the evaluation for the purposes of a custody. In other words, that the evaluation was done because there's a custody battle, which isn't true, and unknown whether true or not. Plaintiff was unaware that an evaluation kept the defendant out of jail for the personal protection order. That's what it says in the evaluation itself, that the evaluator gives credence to defendant's actions, and she gives credence to his actions based upon him having lost custody of his children and wanting his children back. But what the court needs to realize, it wasn't that he lost his children's parenting time and then had these actions. These actions are the reason that he lost parenting time with his children. And again, we just want the children to be safe and what's in their best interest. Based upon the inaccuracies, the results cannot really be for the purpose of the test and the reason for the test and what it's about. I don't think that the results can even be given credibility. We do know that this morning counsel has indicated that he has no anger issues and that we should go back to the way it was. But as recently as Saturday of this weekend, the defendant sent a text, mistakenly apparently, but still said a text that says, quote, "I'm going to tell this lawyer off. She's telling me I have court at 9 Monday. Then also a text saying, apologizing to his daughter and saying that he is just trying so hard to get you back and I just can't win. I worked 5 days straight and I'm just mentally exhausted. I'm so sorry, honey. I just want you back. But mom doesn't want that." Again, a violation of the minor child's inalienable rights, an attempt to get the child to be angry with mom because that she can't see dad, and interfering in that relationship. So clearly there are still ongoing issues. We're asking at this point that, and I'm cognizant of the fact that counsel has indicated that grandma is willing to step up. We would be okay with supervised parenting time with grandma. We have a really hard time with the idea that after dad has gone for a long time now, without having the kids with him, that it would be for an extended 9-day period. So if we could somehow work that out in either trade spring breaks or something along those lines, that would be better. We're also asking that this court require defendant to comply with the mental health treatment as set forth in the judgment of divorce and comport with the parties' agreement regarding drug and alcohol assessment, with the defendant required to undergo any recommended treatment as a result thereof. It appears from the police reports that alcohol may have been involved in the what transpired between defendant and his girlfriend over the New Year's weekend. We're asking that the children be evaluated with recommendations for any treatment as it may relate to any kind of trauma from being in dad's care and improving their relationship with the defendant. The defendant be required to participate in any recommended therapy with the minor children as may be requested by their therapist. We're asking that the court require defendant to undergo the healthy relation. The plaintiff was told as part of the PPO case that defendant is to undergo a healthy relationships course, and that was supposed to occur in resulting from the personal protection order. There's no, in the violation thereof, actually, there is no indicator that that's happened, although that was part of the agreement and that was made with the plaintiff in that case. So at this point, based upon the fear and all the other things with regard to his regular parenting time being supervised, the plaintiff is okay with that as long as it's supervised by grandma, meaning his mother, defendant's mother. But with the domestic violence and other things, we just, with no supervision, parenting time is not in their best interest until we find out what's going on with them. What is the reason for this happening? Because it was a 180 turnaround for the minor child, the older minor child. And let's look not at the defendant getting or not getting his parenting time. Let's look at these children and find out what's going on, why the big change, what's going on that's an exact opposite of what had been happening prior to that, and look at their best interests and their needs. So at this point, I would ask that the court not allow extended parenting time unless, if grandma's able to supervise it the entire time, that's fine, but we would need to verify that first. Otherwise, if it's just the alternate week parenting time, having grandma supervise is fine with the plaintiff. The defendant has not been exercising Wednesdays anyway, and I believe he has to let her know if he plans to in advance anyway. So I don't know that that's such a problem because, again, grandma could contact her and let her know. But at this point, to go back to the unsupervised schedule until
Thomas, please wrap this up. I don't have all morning for this, okay?
That's fine. Yep, that's fine. So to go back to the unsupervised parenting time without finding out first what's going on with the children and their best interest is not good. It's not a right decision in this case.
Okay, thank you. Well, in this matter, as Ms. Henderson stated, that she didn't know if the court would have granted the motion had the defendant appeared, but the fact is the defendant did not appear, and obviously he was aware of it. He could have appeared, could have requested an adjournment, or any number of other things he could have done. He didn't do, and there's consequences for not appearing in court. The court will not grant the motion to reinstate at this time, except insofar as the court will grant the defendant parenting time that is supervised by the paternal grandmother. And the provisions are such that the grandmother has to be present at all times during the parenting time. So if she's not able to do so, then he wouldn't get that particular parenting time. Court will do that. The court will order that the children would continue in counseling and the parties would participate as recommended by the counselor. Court would order that the defendant would participate in a healthy relationship course, and further that he would comply with all the provisions related to the judgment of divorce. And court will allow you, Ms. Henderson, to prepare that order, submit it under a 7-day notice of entry. And after we've had some of that counseling completed, have recommendation, then you can contact the court and we will set the matter for an evidentiary hearing.
Thank you, Your Honor. Is the parenting time schedule provided grandma can supervise as provided in the judgment of divorce at this time?
I have not changed that other than making it supervised.
Thank you, Your Honor. She will be able to supervise all of it. Thank you.
Court will end this matter at 9:19 a.m. You're free to go. Have a good day.